Hello, everybody. Thank you for joining us for our CLE webinar series. We're pleased to be able to continue to bring you current and relevant information, even though we're unable to connect in person. A few housekeeping items to take note of. Presentation materials can be found in the materials box in the upper right of your screen. You may download them at any point during the session. Due to the high volume of attendees, all lines are muted. Our speaker will be monitoring the Q&A box, so please be sure to submit any questions there. The following are a few important items regarding CLE credit. Please keep the webinar window open and at the front of your screen. This is especially important for those seeking Kansas, New Jersey, or New York credit, as you will need to enter a code word at some point during the presentation. As mentioned, if you have a Kansas, New Jersey, or New York license, you will be required to enter a code word. During the presentation, a pop-up box will appear. At that time, our presenters will state the code word and a slide will show the code word. Please enter that word in the box at that time. Again, this is only required for those seeking credit in Kansas, New Jersey, and New York. If you do not require credit in any of these 3 states, the code word is not required and you may close the box. Credit for our webinar has been approved for Arizona, California, Georgia, Illinois, Kansas, Missouri, New Jersey, New York, and Texas, and it is pending in Virginia. And without further ado, I'd like to turn it over to Stafford Matthews.
Hello, everyone. Good afternoon. Good morning for a few of you. I'm Stafford Matthews, the managing partner of Silicon Valley of Dentons, and we're going to be talking today for the next 90 minutes about contracts for the next catastrophe, focusing on advanced drafting tactics. We're going to start with a discussion about supply chain, discuss concepts organized around something loosely referred to as force majeure, look at a whole series of drafting challenges that exist that you hopefully will find very useful. And then we're going to focus on mitigation and the other party's remedies when a force majeure event occurs, and hopefully offer some innovative or different approaches to that than maybe the norm. With all of that in mind, we're going to start by discussing the supply chain. The other thing I want to mention is that this is a large group of materials. There's 135 slides. We're not going to dwell on every slide. It's designed as a reference material for you. Every slide has footnotes to relevant case law. It's in prose, it's certainly not in poetry, and hopefully that'll be useful to you as a reference material as you continue to practice law in this time of potential catastrophe, certainly global meltdown. Let's start with talking about risk to the supply chain. Well, supply chain has a number of different definitions. It's essentially the steps that it takes from raw material through a product in its original state to a customer. And over the past few decades, as we all know, companies have focused on optimizing supply chains, lengthening supply chains for the production and distribution of products and even services. And the increased complexity and specialization that accompanies that focus makes companies more interconnected and dependent, which means that the risk of disruption due to adverse events on a global scale becomes more of a challenge. And I think we all have been living what happens when this risk of disruption accelerates, both in number and in potential impact. These can include the current pandemic, mass flooding, heat waves, hurricanes out here in California, bad fires, geopolitical instability, trade wars, cyber warfare, breakdowns in the financial and banking system. All of these things have an adverse effect on the global supply chain. And we're living, as we know, in difficult times. Of the past 12 pandemics throughout all of recorded history, 2 of these have occurred in the last 10 years, including a number of additional large-scale epidemics. And as we know, the past 5 years have been the hottest in record globally in the past 100 years. We could spend the next 90 minutes talking about those issues, but we're going to focus today on force majeure. The bottom line here, though, is that this new standard, this new baseline involving supply chain is guaranteed in the face of a catastrophe to result in more disruption, to result in longer and higher impact disruption, and fewer sources of supply. And that's the dilemma you face in drafting a contract involving goods or services in 2021. Let's talk about force majeure principles and move on from there. The basic rule in the United States, the default rule, is that contracting parties are strictly obligated to perform their obligations under the contract. And the only case where that's not true is where there's some exception stated in the contract itself, or there's a judicial or statutory exception not contradicted by the language of the contract. Oliver Wendell Holmes said a century ago, you can bind yourself to perform acts over which you have no control. That's the baseline under common law, contract law. Now, the legal principle of force majeure, which can be interpreted as a greater or important force, can permit a party that's impacted by an extreme event to delay or excuse contractual obligations. These are force majeure events that you're familiar with. We highlighted them in the context of global supply chain disruption, earthquakes, terrorism, governmental action, shortages of power. I also think it's probably worth mentioning, I say in the footnote that la Majeure in French also means the middle finger. How that applies to your transactions, I don't care to comment, but there's some connection there, I'm sure of it. Now, force majeure is rooted in 3 universal theories of contract law, which state that there can be an excuse due to what we refer to as a supervening event under one of 3 principles. The first is the doctrine of impossibility, which means that the actual performance that you're obligated to deliver is impossible. The thing actually can't be done. Second is frustration of purpose. It's the thing can be done, but the reason for doing it no longer exists. So the underlying purpose of the contract itself can't be achieved, even though neither party is at fault. And the final doctrine we're dealing with here is the doctrine of impracticability, which is the performance is possible and the purpose of the performance can be fulfilled, but doing so becomes economically senseless in extreme circumstances. So let's talk about a couple of examples of how these apply in practice. And these are doctrines in common law that apply unless the contract contradicts this. So first, impossibility. An earthquake destroys a manufacturing facility, makes it impossible for a seller of machines to install those machines in the building. It's impossible for them to do that. Let's take this a step further. The essential purpose of building new worker dormitories next to the factory has been negated, so there's a frustration of purpose. You could do it, but there's no point. There's no factory, no need for worker dormitories. And the last doctrine is impracticability. Let's say in connection with the earthquake, that there was a large chemical spill and it contaminated the property, making it cost prohibitive and impractical to remediate that problem and construct a new facility on the site. These are the different way these principles kind of interact. And as you can see, there's times when all 3 of them apply. But the basic concept underlying all 3 is this, that there's an unforeseeable occurrence of an event, the non-occurrence of which was a basic assumption by the parties on which the contract was made. The non-occurrence of the thing that occurred was a basic assumption. And had the parties believed that this occurrence would have happened, they would have changed their transactional obligations and rights. That's the idea behind it. Now, there are a couple of subtexts to this set of principles. The first is that economic loss or hardship alone generally is not sufficient to invoke impossibility or frustration of purpose. It can be sufficient for impracticability, but only if that impracticability is really severe. there's case law that says that if the financial difficulty of performing will cause you to be bankrupt, that's not enough of an excuse to make it impracticable. It's not economically senseless for the transaction to occur. It's economically senseless for you to perform. And that would be the way I would distinguish those two. Now, as I indicated, these doctrines are gap fillers. That is to say, they apply in the absence of unambiguous contractual language, including the force majeure clause, to kind of stuff the channel, so to speak, that allocates the risk of events as between the parties. So these rules are applicable unless language or certain kinds of circumstances indicate to the contrary. And that goes to issues of intent and so on. Now, they're not only common law doctrines which apply these principles, there are statutory versions as well, and I'll just highlight a few of them here. The key one in the case of the sale of goods is section 2615 of the Uniform Commercial Code, which only deals with force majeure applicable to sellers of goods, and it excuses the seller from performing under the impracticability concept in the case of an unforeseen event. And it has other obligations. If you can partially perform, you're required to. It gives them rights to allocate goods between buyers which are not necessarily in favor of a particular buyer, that is, your client as a buyer or your company as a buyer. So the statutory version associated with the Uniform Commercial Code is not particularly helpful to buyers. And it's one of the things that you want to address in drafting your contract. This rule is overridden to the extent that the seller undertakes additional obligations, and that's a code word for a force majeure clause that defines what the seller does and doesn't do. There are other state codes. In the state of California, if there's an irresistible superhuman cause or the act of public enemies of the state or the United States, that will relieve you of the obligation to perform. It says, unless the parties have expressly agreed to the contrary, and that's language that was written in 1872. So there are state statutes you need to be mindful that apply even in the absence of conditions that wouldn't necessarily work for you under the common law doctrine. An important statute or treaty, I should say, that you need to pay attention to, and I find in my practice dealing as kind of a forensic lawyer and dealing with contracts, including a lot of contracts that are being re-examined after the fact, has to do with the the UN Convention of Contracts for the International Sale of Goods. Now, the CISG has rules for force majeure events, and over 50 countries are signatories, including the US, China, and most major European Union countries, although the United Kingdom is not a signatory. Now, you can opt out of the rules that the convention has, but here is the situation. As a treaty entered into by the United States, the convention is deemed part of US law and part of the law of every state in the United States. And unless the contract excludes the application of this convention, it will preempt and override any other domestic law in your state choice of law, including the UCC. And the rules associated with force majeure and other rights and obligations of sellers and buyers under the UN Convention are different than they are under the UCC, and to some extent different than they are under common law. So you need to be mindful of the fact that if you have a contract for the sale of goods and you do not want the convention to apply, and you have parties in multiple jurisdictions that are signatories to this convention, you have to exclude it. And if you fail to exclude it, the rules of this convention are going to apply to your sale of goods transaction. So core points before we move on. By the way, we're stepping, I think, briskly through these concepts to set the stage. We'll be focusing more intently on a whole series of other issues that require a more deeper dive. and look forward to sharing that with you shortly. So, core points. Common law and statutory rules can excuse a party from performing under the contract in the case of events which are not within the contemplation of the parties. To counteract this outcome, the relevant parties have to actually draft and include contract language to deal with the concept of a force majeure, a supervening event, sorry. Now, the entire objective of your drafting and negotiating this part of your contract is to shift the risk of unexpected events to the party who is supposed to bear that risk, and then to have that allocation of risk enforced. To shift risk, that's the concept. So, with that idea, the question you always have to ask at the beginning, middle, and end of your process is, which party bears the risk of force majeure or a similar unexpected event? Which party bears that risk? Because if you just use a standard clause, that is not necessarily close to what you want in your transaction. Let's talk about the clause. This is an example of a force majeure clause. It's far from perfect. It's indicative for your materials to take a look at. And as I indicated, parties can contract against force majeure, and if done correctly, and oftentimes it's not done correctly. We're going to try to help remedy that today. By use of a force majeure clause that qualifies what qualifies as a force majeure and the actions required in the event this occurs. So a force majeure clause, if properly drafted, allow parties to negotiate consciously and correctly draft the scope of qualifying events and any excusable obligations. What the non-performing party has to do in terms of providing notice and mitigating the effect of that event, and the options and remedies available to each party, including the other party to the contract. And we're going to spend a lot of time at the end of the presentation on the other party, because that's almost never in any force majeure clause, ever. So we'll talk about that. Now, force majeure clauses are generally interpreted under the same rules governing any other contractual provision, which means that the courts will accept the language, but because it constricts obligations, they will interpret it narrowly, that is to say, and focus on the specific language of the force majeure clause to establish what the scope of that provision is. There's a case in the New York State courts which says it best, I think. It says when the parties have themselves defined the contours of force majeure in their agreement, those contours dictate the application, the effect, and the scope of force majeure. Now, here's the baseline, the practical baseline of what we're dealing with here. And then we'll move into the clauses themselves. Principle number one is that the force majeure party, the one suffering the force majeure, is a sole beneficiary, sole intended beneficiary of this contract, because it relieves that party of its otherwise strict contractual obligations under the contract that you, as the other party, negotiated and are depending upon as part of the transaction. And in fact, this is the sole purpose of the clause, is to relieve the other affected party from its obligations. Now, because that party is relieved of its obligations, and there are some technical ways to draft this we'll talk about, their failure to perform is not a breach of contract. The other party has no claims, no right for damages, no right for compensation of any kind if there's a force majeure clause that excuses the affected party from performing, unless you put it in the contract. In any sale of goods and any service contract, and frequently even many license agreements, these kinds of clauses, and this includes the consequential damage provision, it includes other provisions of that type involving limitation of liabilities, they're not mutual. in the case of only the seller of goods or the performance of services usually is the party affected. The other party's making maybe their facilities available and writing a check. I know it's simplistic, but conceptually. So there's no mutuality. When someone puts a force majeure clause in and you're on the other side of that, they say, well, it's mutual. The concept is false. You need to actually address what's going to happen, and that rarely occurs. Because of the way force majeure clauses are drafted when they're attempting to list, sort of large-scale terms like epidemic, pandemic, and so on, boilerplate clauses are inherently ambiguous. They use broad and nonspecific terminology. And that's going to be subject to litigation, and you've seen that in the case of the COVID-19. And finally, the other party who is not affected by the force majeure, but is sitting there waiting for performance, there's no contractual excuse. We'll talk about what your rights are as the other party. But usually there's no contractual excuse. There may be a termination clause, but there's no clause that says, oh, and by the way, the other party doesn't have to perform, the other party doesn't accept late performance, et cetera, et cetera. Never says it, ever, hardly. And I'm going to provide you with a whole series of solutions to address that problem. Now, for convenience in these materials in our conversation, because of the flow of the transaction, when we talk about contracting parties, we're going to refer to the seller or force majeure party or the buyer in the context of this manufacturing and supply of goods or components or raw materials. It's a convenient way to think this through. But obviously these apply conceptually to service agreements as well. And we're going to talk about all this stuff from the point of view of the buyer. That is to say, we're going to try to address the issues from the point of view of the recipient of the goods and services. Now, because supply chains are complicated, especially if you're dealing with, things like electronic products or any kind of manufactured good that has complexity, has special components, has unusual raw materials, the seller in this scenario is also a buyer to upstream sellers of vendors of things it needs in order to perform its obligations, like manufacturing an iPhone. It needs to be protected as a buyer from failures of its upstream services to perform what they need to do so that seller can perform its downstream service to our buyer. In this context, your company. And so the tactics we're talking about, although the point of view is from the buyer, apply equally to the seller as a buyer within the supply chain, which is where we're focused on that issue. All right, so the first question is force majeure or not? Now, drafting tactics, force majeure, are best understood in context, and in each case you have to figure out your type of transaction and the relationship involved with the parties in order to determine what I call the set point, that is to say your target value. Where do you want to be contractually when you finish negotiating the agreement? Where's your set point? And that's going to depend on circumstances, and I'm going to talk about 4 different kinds of circumstances which are not at all exclusive of many other circumstances that will give you some idea of context for the rest of our discussion. So, and these are the labels I've made up and they're types of transactions I've made up, but I think you'll find they're representative of a great deal of the type of transactions that your company engages in no matter what you do. First are what I call Class A transactions. You're buying commodities. So the seller is selling goods or services or commodities. You have a choice as a buyer of a broad range of group of sellers. So your objective, in my view, is to cut your losses if there are any issues. Get out of the contract, move on, find somebody that can deliver those commodities for you in a situation like that. In a slightly more complicated transaction that focuses on the deal terms, you can have a seller of standard interchangeable goods or services, and you have as a buyer a choice in the market. But there are deal terms or conditions or characteristics of your transaction that are highly favorable to you as a buyer. Quality, pricing, long-term supply guarantees, long-term relationship, a satisfactory relationship in your supply and vendor relationship with this entity. So the terms themselves are worth protecting if you can. So your objective in a force majeure scenario is to protect your favorable deal terms. And we have some tactics for dealing with that. Next, we're, again, increasing in complexity. We're dealing with a product sourcing situation. Under Class C, the seller provides necessary materials in a market where there are more limited sources, or there are really long lead times, or the product design or other supply chain is really complicated. Maybe producing a component of some kind that's been designed. And so access to change of sellers is more difficult. There's a barrier to entry with another seller. And so your objective in that situation as a buyer is to ensure, to the extent possible, continued sourcing of what you're wishing to have. And then finally, we have a critical component scenario, where maybe the seller is the only supplier of some critical component because of a rare material, or again, because there's a complicated design scenario, or they own the patents that allow them to produce this component and no one else produces it, or their manufacturing process is particularly effective and they own intellectual property rights on that. You could also be in a situation where you're jointly developing products or components. We work on those deals all the time, or shared trade secrets, where there's some technology licensing going on between the parties. And there, your objective is continued access to those critical components. It's an urgent version of Class C. As I said, these are categories are not exclusive, and it will depend a lot on the concept of leverage. So you can have a Class D transaction where the seller is the sole source of supply, but the buyer is the largest customer, or the customer that has validated the technology. So the buyer has substantial leverage in the deal, and the seller wants to bend over backwards to satisfy the buyer's demands. So it really would depend on context. But within the context of force majeure, the obligation of a party to perform can fall along a series of spectra, And the spectrum here has a series that I'm going to talk about. In the strict performance category over to the left, there are no exceptions you have to perform. And one version of that is something that's called a hell or high water clause, and we'll talk about that in a minute. You can also just not have a force majeure clause, and then you have to deal with whether the state or jurisdictional or common law or civil law principles apply to excuse the performing party. Then you can be in a situation where you're in the heart, the middle of negotiating force majeure clauses. We're talking about very specific types of events, some obligations to mitigate, referred to as a narrow exception. Moving further towards freedom for the performing party, you can create broad exceptions, and there's some industries that do that. They have model contracts, like in the architectural industry. They have model contracts which have very broad exceptions for any event outside of the reasonable control of the party, with limited obligations to mitigate depending on the circumstances, and broad exit for the seller in that situation. You can actually take it a step further and have what's known as a hardship clause. We'll talk about all these in some more detail, where not only not to perform, you can judicially force the other party to negotiate new contract terms to alleviate whatever problem you're having. So let's just move through these, and then we're going to focus on drafting the force majeure clause. And we're really going to focus on mitigation issues. Hell or high water, no outs. Buyer negotiates language that says the seller is responsible for any failure or delay in performance, period, even in the case of a force majeure event. And these are known as hell or high water clauses. And this is an example. And I should mention that I have lots of clauses built into these materials for you which are not perfect, and I commend them only as a starting point for your thinking and drafting, but I hope they'll be helpful to you. And we have examples of these taken from industrial contracts and other places. There aren't any actual published decisions we could find on whether hell or high water contracts per se are applicable in the force majeure context. You know, there's a force majeure clause. But there are government contracting provisions like this, leasing agreements, oil rigs, where this kind of clause is not atypical. And this is true to require performance even when the performance is impossible. Per Justice Holmes, you can agree to perform even though circumstances make it impossible for you to do so. That's just a risk shift to the seller. Now, it's not necessary to simply not have a force majeure clause. Just not having a force majeure clause in your contract doesn't save you, partly because of all these statutes and the common law doctrines that we've talked about, frustration of purpose and possibility and practicability and so on. It's not okay to just leave it out and feel you're fine. You're not. So setting aside the hardcore hell or high water clause, you need to focus on what you do, what's going to happen if there's no force majeure clause in your contract. You can't negotiate one out and go tell your GC that everything's fine because of these doctrines that now will be applicable because the contract doesn't deal with them. So one of the suggestions would be to have an express waiver in the contract of these applicable doctrines. And this is an example of that. That no event of force majeure, any occurrence of any kind, whether foreseeable or unforeseeable, should exclude seller from the performance of its obligations. All doctrines of XYZ are waived. Now, the third category of these clauses is the force majeure clause. And we're going to talk about these in detail. And finally, we have hardship clauses, which I alluded to. It's a separate category of clause, which says if you have such an event, usually it's referred to as an excessively onerous event. You have a contractual clause which says the parties are obligated to negotiate alternative contract terms to take into account the consequences of the event. And these hardship clauses are uncommon in the United States, but if you're a seller and you have enough leverage, I would strongly recommend that they take you a step further from force majeure. Now, be careful if you're doing deals outside of the United States, where most transactions are governed by civil law. Civil law has as its common feature the concept of a hardship clause. And I cite the French Civil Code here. You can take a look at that if you wish. But you need to be careful when you're outside the U.S. It's an add-on that you need to take into account. And this is an example of a hardship clause. Let's talk about drafting tactics. That's actually the title of our presentation. General structure of a force majeure clause has 5 parts. First, there's some statement that there's a delay or excuse of performance if the force majeure event occurs. There's some specific list as to what qualifies as a force majeure event. There's some concept of notice. There's some idea that the force majeure party, meaning the seller or the affected party, has some obligation to mitigate the effect of the events. Although most of these clauses are monumentally weak and ambiguous and vague in scope, something I'm going to try to convince you is a really poor idea and one that you can solve. And then finally, it may have, it frequently doesn't, but it may have other remedies that the parties have either initially at the time of the force majeure or as the force majeure event continues unabated past some stated period. It's common to put some termination clause in there, but that doesn't solve your problem if you're a buyer, except at the end. Now, as a party, if you care about having an effective and efficient contract. There are two core objectives that you need to take into account. And this can apply to other clauses as well, but it really applies when you have an external event triggering some shift of the parties that was unexpected. And it's optionality and speed. You need to find a way to absorb the shock. So a menu of rights or remedies, which would be the best response under the circumstances, is what we mean by optionality. And almost no standard force majeure clause has it. But we're going to try to solve that today. Next, speed. Some means of asserting the rights and remedies of the party quickly and unambiguously, if possible, without going to court. Again, almost no standard force majeure clause has that either. So we're going to try today to encourage you to open up your minds and your pens and your laptop to a new kind of clause. So first two sections of the force majeure clauses are the excuse and deferral of the obligations and the specific events. And these in turn break down. This is why I just have a whole series of bullet points. Some detail is necessary here. These sections break down into the following core elements. Are you excusing somebody from performing, or are you just deferring their performance? Causation. Is there a connection between what happened and the obligation to perform? Conditions of control by the affected party. Categorical exceptions to the application of that clause, things that you have to continue to do as the affected party, even though you have a force majeure situation. And then the listed force majeure events in a case where those events are listed. Excuse versus deferral, causation, control, exceptions, and listed events. We're talking about each of those. Now, excuse versus control, these are things taken from some contracts on my desk. No party shall be liable for a failure or delay. So it's no liability, no breach. Or a party shall be temporarily relieved in the performance of its obligations. It's almost a waiver of performance. Or I've seen this, a party will be temporarily excused from any default or delay or failure, which is kind of a hybrid, but they're different. Now, as I said, these clauses take one of two approaches, either to excuse from liability, which is a direct excuse, or to temporarily relieve from the performance obligations. And in most cases, it's not a material distinction. Like I said, people use temporarily excuse. But an excuse from liability is really less precise and more ambiguous, in my opinion. Reasonable minds can differ. Than temporary relief, assuming that you intend that there be performance at a later time. Conceptually, there's something to be said for just relieving the party rather than excusing them from liability. But in many cases, it may not matter. Just be mindful. It's really important, though, that you coordinate the clause with the expiration terms in the contract, when the contract expires, or may be terminated for other reasons. So if it's really critical, if you're the buyer, and it's really critical for you to gain this performance, you may need to extend the term of the contract or require some sort of post-termination performance obligations by the seller to avoid a situation where the seller runs out the clock because of force majeure on its obligations of the contract. You have a force majeure situation and the contract gets, I'll just randomly say 9 months to run. Sound familiar? And the force majeure allows that seller to not perform during that period, and then the contract terminates by its terms. What's the outcome? You've negotiated for this performance. If you're a buyer and you don't do it right, you're stuck waiting for it. And then your contract's over and you haven't received the performance. It may be appropriate for you to say in your termination provision that you extend the obligation to perform by the term of the force majeure in order to get that component or that service that you require that other people are not going to be delivered to you. That's sort of data point number one on that. Let's talk about causation. It's really important if you're the buyer that the cause require a direct causal link between the force majeure event and the non-performance of the seller. The court hold it's always necessary for the seller to establish some kind of causation. And I have in this footnote on this slide a bunch of cases that were decided in a couple in the last month or two or three on the pandemic and whether it works or doesn't work. And these kinds of cases are rolling out now in the courts. Bear with me for one moment, please. Someone asked, I apologize for not picking this up earlier. Someone asked if the convention for the international sale of goods applies only between different countries. The answer is yes. If you're in the US, it doesn't apply. Someone's really asking here about hurricanes and Gulf Coast. It's really an issue of foreseeability, and we're going to talk about that in a little bit. These are all great questions. I may not be able, by the way, to answer all your questions during the time we have, in which case we will pick those up afterwards. I'll reach out to you directly in that regard. It needs to be a direct causal link, and it also shouldn't be self-inflicted, due to the fraud, fault, or negligence of the seller. And we have some examples of clauses here. Now, when we talk about it being caused by the event, you have to really watch out for this. Be cautious of things that say non-performance arises out of or relates to the force majeure event or is in connection with the force majeure event. This kind of language, which has been heavily litigated by the courts, has been significantly undermines the causation link and expands the scope of the clause. It's a concentric circle of arising out of, related to, or in connection with. There can be broad distance between the event and the claim of the inability to perform because of the event as you expand the scope of this clause. These are words that are fraught with meaning and have very different outcomes in a close call. So be careful of that. If you're the buyer, you should have a direct causation language. You can also limit the scope of the force majeure clause by saying that you're excused from performance solely to the extent caused by force majeure. To the extent or solely or a combination of the two require that to the extent the seller is not prevented, it needs to perform. And that also narrows the clause. Now, the third category we deal with is the control of the seller. And the classic example is you have excuse from performance due to causes beyond the reasonable control of the affected party. And this is really common language. So first data point, I think we all understand, is experienced contract lawyers, experienced litigators, and I do both, that the term reasonable is entirely dependent on the particular facts of the case. There's no general category, mainly, of reasonable. People try, but it's inherently ambiguous. Now, when the courts look at this, when they talk about outside of the control, they interpret it to be a sudden and unforeseeable event, not circumstances where a party could have taken steps in advance to avoid the force majeure event. When we talk about mitigation, we're mainly talking about mitigation after the event occurs, but there's a separate concept of mitigation, which you should adhere to, which occurs before the event of force majeure. So you can have more stringent language saying it's outside the control, or if you're forced to negotiate that, the reasonable control of the seller, and which by exercise of due foresight could not have avoided the event. And by exercise of due diligence could not have overcome the event. A less eloquent way of saying it is, it's outside of the control of the seller with the exercise of due diligence or best efforts, and without its fault or negligence. Now, if you agree to a clause which speaks about an event being outside the control, in this case of the seller, there's been extensive litigation as to whether that outside of control requirement covers sort of everything in the clause, or whether a specific listed event, pandemic, is deemed per se to be a force majeure, whether or not it's within the control of the party. And the exact order and location of this clause becomes very important to avoid some fairly dramatic shifts in your expectations as to what you thought this contract clause said. So if you want to have a statement that says that the seller can only be excused from performance if the event was outside its control, no matter what, you would use language like this. The obligations of a party are excused for any failure or delay in performance, which is outside the reasonable control of the party and caused by, fire, flood, et cetera, et cetera, et cetera, et cetera. So it requires that it be outside its reasonable control in all instances. You can also, if you're the seller, particularly have a more limited control requirement, which you can say the obligations of a party are excused for any failure to perform caused by, flood, or any other cause outside of the reasonable control of the party. And the courts would view this very differently. So you need to be mindful of the order of things. Now, the fourth category we're dealing with are excluded classes of events. If you're the buyer, the non-affected party, the recipient of performance, it is prudent for you to expressly exclude certain generic classes of events, even though they're force majeure, and what kind of obligations to perform there are. So for instance, even though there's a force majeure event, you might say that any payment obligations of a seller, this may or not occur. Oftentimes you're really dealing with payment obligations, obviously, of a buyer. But any payment obligations of a seller, any indemnification or defense obligations of a seller. You can exclude financial hardship generally, so that you could say, well, you're excused, but the fact that you're not prevented merely because it's financially hard is not an excuse, and you have to continue to perform. There are times when sellers will say, well, the changes in cost or availability of materials is something that is been made more difficult, and therefore the force majeure excuses me based on that impact. You can provide that's not the case. Any changes of marketing conditions generally. Any disputes the seller has with an upstream supplier, or any failure of an upstream supplier to supply. These are things that you can exclude from the effect of the force majeure. So even though the party affected may be generally excused from performance, they aren't excused from financial, indemnity, or market condition type of events. You could say, notwithstanding any contrary provision, none of the following events will excuse the delay in performance. And you go 1, 2, 3, 4, 5, and you've covered yourself in that regard. Now it is time for the code word. And the code word is olive oil. Olive oil, actually code words, and it's time for you, if you're in New Jersey, New York, or Kansas, sorry for that, Kansas, to put the code word in the Q&A section on the screen. And we'll wait a moment for you to do that. Hopefully that's sufficient. Now, let's talk about scope. What force majeure events apply? Either you're going to have a general concept of a force majeure event, or you're going to list a finite series of specific classes in your event. And you can have an unrestricted general clause that talks about, anything that's unforeseeable, anything outside the control. It's certainly pro-seller in that situation. And this is an example of that type of clause. Any event which is not within the reasonable control of the seller, say it that way, depending on your lack of leverage as a buyer, or you might add the issue of due diligence, you might add the issue of failure to overcome. And a finite list of force majeure events is generally pro buyer. You have more clarity, but it's narrow application. Now that gets completely undermined if you allow what's known as a catch-all clause. And we'll talk about those in a minute. Now, when you're preparing your finite list, if you go that route, and that would be typical, the challenge you have, and we're experiencing as people are litigating the heck out of COVID-19 right now, is you have to have enough specificity to anticipate how the provision is going to be applied by the courts, while providing enough flexibility to cover a new type of event that's similar or relevant. And it's almost an impossible task to get right. Many people are finding it out now, but that's the challenge, that's the job. Now, listed events are usually industrial, geographic, or context specific, but they're usually selected from the following categories, which I'm just offering to you for your consideration in your next drafting job. They can be weather related. They could not be weather related, but naturally occurring, like a tidal wave or a volcano or earthquake out here. They can deal with disease, which not only includes pandemics, but pest outbreaks if you're dealing with agriculture or a plague. It can deal with governmental authority issues, which can include nationalization, depending on the jurisdiction you're in. Bear with me one moment. Okay. Thought I had a question, but apparently not. It's fine. Acts of war, acts of terrorism, combustion, which is a fire, explosion, an implosion, computer-based events, which you should consider, cyber warfare, ransomware, other cyber attacks. Your entire network's taken down for a period of time. That's a legitimate force majeure event, one would argue. But it needs to be in here because when you list these things, the court will look at them narrowly and will not include events which are not within the narrow scope of what you're providing. Labor issues and interruption of trade or facilities. It can be failure of the power grid, telecommunication systems, there's no internet, interruption of transport or other infrastructure. Well, during the fires last year, the electric company shut down all electricity in 6 counties for 2 weeks. No one could operate anything. Those are the kind of issues you may be dealing with. And that was a knock-on from the fact there were fires. Now, as I indicated, if you don't list an event, the majority rule is that events that are omitted from the list are outside the scope and not force majeure. So what sellers, potential affected parties do, is often add a catch-all phrase to expand the scope. But there are problems with the way those are drafted. Common language includes finite list, including without limitation, or other events which are similar or dissimilar to the foregoing. Or, as we saw in connection with control, a list of different events. And a catch-all which says, and any other events beyond the reasonable control of the seller. Acts of God is actually a catch-all phrase, but take a look at the definition if you have a moment. It requires exclusive forces of nature without any interference of human agency. So acts of God is actually relatively limited. If you have a particular concern, like an earthquake, some courts hold that acts of God only relate to weather. You want to lay it out. Now, there are a couple of caveats you need to pay attention to in connection with this catch-all phrase, which is really common, and with good reason if you're the seller, because you're attempting to negate the court's narrow interpretation of your clause with the inability potentially to predict during the course of the transaction everything that could go wrong. There is a maxim of jurisprudence, maxim of interpretation called justum generis, depending on the jurisdiction. And this doctrine can crush you on this catch-all. The doctrine says that general words that follow a specific list You first have a specific list of terms, and then you have a general term. The general terms following specific lists are not given an expansive meaning and are deemed to only include items of the same or similar type as was listed specifically before. So you've got general words following a specific item, like a general catch-all phrase. And there are courts in this country that hold that it's not broad, that it just means things of same or similar type, which doesn't get you frequently where you want to go. Now, application of this doctrine of estitum generis is not mandatory, and a lot of courts say it's not mandatory. It can be challenged if you can prove intent, different intent, but you have to prove it. So what parties do is they say things, and I alluded to this before, is you have a specific list, and you say, and other similar or dissimilar events beyond the control of the seller. Most people feel that'll do it, but you've got to break it out. Now, the second problem involving having to do with this maxim is you can also counter it by the internal order of the provision itself. We talked about internal order, for instance, in the case of the control provision. But it's relevant here because this particular maxim only applies, as I said, when there's a general catch-all phrase after a specific list of categories. So if you have the catch-all phrase first in order, then the rule's not going to apply. There's some case law that says this specifically. This is the sort of thing courts deal with when they're dealing with these types of clauses. If you say any events beyond the reasonable control of the seller, including but not limited to, or similar or dissimilar to the following, because the general language is in front of the specific language, the rule doesn't apply. Now, the other catch-all caveat is the common law statutory defenses we started with. One of the things you need to watch out for is a tactic that a force majeure, a highly evolved force majeure party, would try to insert common law defenses into the force majeure provision, essentially negating the allocation of risk. So you can say the parties will be excused if such performance is impossible or commercially impracticable, when the event of frustration of purpose as a direct result of any event beyond the control of the party, and so on. You see these sometimes mashed together. You need to be mindful of that. To minimize that risk, you should consider a couple of things. You can consider an exclusivity provision that says that the things we just listed are it. And we don't intend, we're creating intent, we don't intend to include anything else. You can also include a waiver of the common law statutory defenses, which I would recommend if this is important to you, even when you have a force majeure clause, to make sure that if there are gap fillers, they don't fill your contract because you specifically waived them. And again, this is a clause which could assist you in working this out. Now, this was raised by one of our friends in the audience a little while ago. We get hurricanes every year. They're foreseeable. Does the force majeure clause work then? And the baseline principle is that it's entirely possible by contract to relieve a party from force majeure events, whether the events are foreseeable or not. And in absence of clear language, the courts generally in the US say that the extent you have a specific list of force majeure events, it doesn't matter whether they're foreseeable or not. You've agreed that they apply. And you're excusing the other party, excusing the other party from the concept of foreseeability. And then the courts also say, though, that if you're talking about some sort of catch-all language, because the parties didn't have that specific event in mind, there has to be foreseeability in that situation. So if you're a pro-buyer, you're going to say, you're going to try to negate this a bit by saying you need foreseeability in all events, whether they're listed or whether they're general. If you're the seller, you're going to want to omit foreseeability to the extent possible to maximize the scope of the clause and maximize your relief. Now, you can tell from this discussion and the fact that I've alluded to a whole series of cases that this is an issue which is under intense scrutiny all the time. It's litigated all the time. This pandemic qualifies, it doesn't qualify. The pandemic occurred, it hasn't occurred yet. It only occurred in Asia. It hasn't occurred yet in Canada, and so on and so on. So it makes sense, if you can, to try to create some system for objective confirmation of force majeure status. When did it occur? And the parties can provide for this objective and neutral confirmation. So you could say, and some people are doing this now, a pandemic that is subject to an official declaration by the World Health Organization, the Center for Disease Control, and so on. Declarations by a state of emergency or formal action by a governmental authority. Some people are relying on that in the case of COVID. And that's objective confirmation. You can put it in your contract. There may be specific objective metrics that relate to the industry. You know, a reduction in productivity of 25% in the industry based on statistics issued every month by some entity. You can also have more detailed provisions for the type of government orders you have. So like bans on access of critical materials. Or, like for instance, the case of Huawei, where the government in the United States, they were an essential upstream supplier, and the government of the United States banned the ability of companies in the U.S. to work with Huawei. And this lists like this, which are promulgated all the time by the government, if that's relevant to what you're doing, they're very relevant if you have technology component types of contracts. You may consider trying to make those objective. Well, let's continue. You can provide for formal expedited discovery. So you can get all the data you need to determine whether or not the seller is telling the truth. Production of documents, the right to site inspections, interviews, or even depositions or retention of experts to figure out whether this thing fits within the definition and has occurred, which is what people fight about. It's also possible to provide for expedited arbitration, some alternative dispute resolution mechanism, so that you can have an arbitrator or an expert determine immediately whether the event that is in the notice that the seller is using in order to avoid performance actually qualifies as a force majeure event, either under the contract clause or objectively as a thing, like is it a pandemic, as opposed to an epidemic. And here's an example of a clause to facilitate that using American Arbitration Association. It could be any arbitration entity. You might consider that. If nothing else, when someone says, I have a force majeure event, I'm stopping, and you disagree, it's a good idea to be able to do something like this in order to settle the issue right then and there, especially if you have a whole series of remedies as a buyer, which we're going to talk about next. At least after making a note that you need to have a clause, part of the clause dealing with notice of event, and how that clause is drafted when the notice is required to be provided, how much detail you need from the other party to determine, at least internally, whether this is a legitimate force majeure claim, are things you should consider. Now, last topic for today. We're right on time. We're going to finish right on time. Our mitigation and remedies. Now, the general rule, as I indicated, there's no liability for the seller. The force majeure clause suspends or excuses performance. The seller is not liable for any additional costs incurred by the buyer if they haven't breached anything. If there are liquidated damages for failure to perform, they don't apply because the seller has done the thing wrong. They've been excused. But you can provide for acts post-event that are loosely described as mitigation to expressly require the seller to undertake certain efforts. Either, as we indicated before, to take precautionary measures ahead of time to minimize the possibility of a force majeure event or the adverse effects of an otherwise unavoidable event. And mitigation efforts organized around trying to end the delay in performance and resume performance, getting around, so to speak, or out from under the force majeure event itself. Now, there are lots of standards that people use for this, and the qualifying language could say you have to take all necessary steps or diligent steps or best efforts, reasonable, commercially reasonable, and all of these have, qualities associated with it. I'm not going to dwell on this, but there's some states that hold that the best efforts clauses without performance metrics aren't even enforceable. I'll leave you to that. Now, if you're a buyer, you need to be wary of general, what I call naked mitigation standards, just general standards. Well, we'll engage in some reasonable efforts to do this. They're ambiguous by design, and they invite certain litigation and have certain uncertain outcomes. So it's really essential in a properly drafted clause of this type that there be specific detailed provisions for the parties on the receiving end of a force majeure provision. And that's especially true where you're dealing with critical components of materials. And you rarely, if ever, see these. And it's a real failure of concept, of thinking, in addition to drafting. And hopefully your consciousness will be properly raised by this presentation. So these mitigation terms could require, we're going to get into this in a little more detail, that that a party pursues secondary or tertiary means of fulfilling the obligations, or required to reorganize its business. For instance, in COVID-19, you can say you have to reorganize your operations to allow employees to work in a socially distanced manner. And that's not going to be in the contract. But there are clauses you could use which would anticipate this, especially now, given perhaps our society's expectations of what's to follow. Now, note that a failure to mitigate can be a separate breach of contract. So even though the person may, the entity, the seller may not be required to perform, the failure to mitigate, if there's an affirmative contractual obligation to mitigate, is a separate potential breach. And you can provide what happens if they fail to mitigate. We're going to talk about that next. So, enter the T0 dilemma. This is the dilemma that the other party has when they receive a notice of force majeure from the seller. The T0 dilemma. That's because this mitigation will only take one of three forms, right? Either the seller will satisfy the mitigation obligations and the delay will end sometime, in which case the seller's not liable for anything and the contract can proceed, assuming it's drafted that way. The seller can satisfy its obligations, but it's unable to end the delay. You still have a pandemic, and the pandemic is still affecting in a material way its ability to perform. So the seller's not liable for breach, but you may, in that situation, provide that this buyer can exercise certain remedies. Or the seller fails to satisfy a mitigation obligation if one is robustly drafted and clearly enforceable because of clarity, lack of ambiguity, and intent. In a situation like that, the seller's liable for breach of mitigation, and buyer can exercise damage remedies, it can terminate, and so on, the general provisions of the contract. But here's the T0 dilemma. At the time the force majeure event occurs, and the seller stops performing, you have no idea which one of those three things is going to occur. You have no idea what's going to happen down the road during the period of force majeure. All the risks at T0, that moment, that first moment in time, sit with the buyer, all of them. Force majeures occurred, performance is delayed, buyer has no idea if the seller is going to be able to resume, even if they discharge their duties, or if they're going to be liable for any failure to comply. You know nothing, and there's no way to know. If you don't provide for that event, that T0 event, and try to address that problem, you're not utilizing the full set of tools in your toolbox in negotiating force majeure situations. Now, the common law does provide some rights to the buyer. Mainly the buyer under common law, and I cite some restatement sections here, has a right to suspend its performance during the period of non-performance by the other party. It may be discharged from its duties altogether if the failure of the seller to perform is incurable. That is, say, the force majeure event doesn't make things curable. But the rule doesn't apply if the buyer, at least implicitly or explicitly, has assumed the risk of performance and in spite of the failure. You also may be required to pay for completed performance or substantial performance by the seller in circumstances that are not beneficial for you. It's not enough. Now, there are some sections of the UCC that I'll commend to you, which you can take a look at. They are limited, other than to get out of the obligation to perform it. That doesn't deal with the damages and risks you're undertaking because you're not getting the performance of the seller. It only deals with the non-performance of the buyer. Okay, so to avoid all these issues, you should include in your contract, if you're on the receiving end of the performance, rights like this. I'm going to break them down in more detail in the time we have left here. Suspending and discharging specific obligations like any purchase obligations, or even the right to refuse tender if the seller wants to perform. The right of you to cover as the buyer and to cancel open purchase orders. Suspending exclusivities, suspending exclusive dealings or non-competition restrictions. And we're going to talk about this at the end, right of immediate termination of the contract. Now, lots of other potential buyer rights, and we'll talk about these now. It's a non-exclusive sort of presentation of possible options to consider, but I will tell you that these can be very useful to you. Now, remember the slide at the very close beginning of this presentation, which said, which party bears the risk in the case of force majeure? And the answer is always going to be the buyer, the recipient, the non-affected party. And most clauses do nothing for that party, except maybe allow them after 60 days or something to terminate. It doesn't solve the problem of components. It doesn't solve the problem of exclusive deal terms. It doesn't solve all those problems, none of them. We're going to talk right now about alternatives you can use to try to shift the risk being allocated to the parties. First one is supply chain sourcing by the seller. You could say, and I alluded to this a little while ago, the seller, if they are, because now we're talking about money, can be required to go purchase substitute components or materials from alternative suppliers at the price the buyer pays. The buyer doesn't pay any more. Seller, no matter what this costs the seller is to go out and try to find alternative sourcing. And again, I have each of these has an example of language associated with it. The seller could be required to reimburse if the buyer goes out and has to cover at prices and costs that are higher than your contract. You can have the seller reimburse you for that. The seller is not liable for breach and for damages, but nothing's stopping you from saying, you were the one that was affected, but now we're affected, we have to go out and cover. And you're agreeing to pay our costs of doing that because we've been deprived of the benefit of our bargain because of a problem you have. One of my first bosses had a bracket, a thing on their desk. And you walk in and all it said was, it sounds like a personal problem to me. That's a little what you've got here. It's the seller's problem that the buyer is suffering because you can have the seller reimburse. And here's an example of that. You can also change the financial terms. You can provide that if there are terms and conditions like pricing of products, these can be modified in the event of a force majeure to compensate the buyer, which otherwise gets no compensation under a standard clause. I can't say that enough. in shifting some of the risk to seller. So for instance, you can have price reductions for the time of performance. So in the case of force majeure, the purchase price of machine should be reduced as follows. First 4 weeks, 0. 5 weeks, 1%. 6 weeks, 2%. 7 weeks, 3%, etc. After 6 weeks, the entity who's supposed to buy can cancel. Changing in terms also can provide not only for an extension of the expiration provisions of the contract, but can also toll the performance obligations as well. So you could say any event of force majeure will defer and suspend the dates and the computation of any times of performance by the seller until the force majeure event is concluded, which means that the seller is temporarily relieved but not excused from performance. The seller will still have to perform when time is up, and to the extent there are time periods involved in the seller's obligation to perform, those are being told, and the seller is still required to pick up the slack. Many of the companies that you work for have business continuity and disaster recovery plans. You can staple that onto your contract and require the seller deal with it. There are a lot of mitigation provisions, a lot of abilities to communicate and collaborate on solving the problem in those plans. That's what they're for. And you should consider inflicting those upon the seller, for lack of a better word. You can have what are known as step-in rights. The right of a buyer to step in and control the manufacturing and supply functions of the seller. Now, we're just going to touch these because it's complicated, but there's a whole lot of information here for you. And this doesn't only happen to be in the context of force majeure. It could be in the case of an epidemic failure rate. You see these sorts of clauses. You see them where there's an intentional breach of the seller. When this trigger occurs, the buyer can step in. They can allow the buyer to directly perform the supply functions, manufacturing functions. You require the seller to make disclosures to you about its designs, tooling, manufacturing processes, and so on, to allow the buyer to do the manufacturing. You can require the seller to transfer all its raw materials to you and maybe execute on raw material purchases. You can have an IP license, which allows you to use their patented manufacturing processes or trade secrets in order to make the goods. There can be issues of whether or not a royalty should be paid for this, or whether it's undertaken in the context of a unit price. You can require that important confidential information, schematics and other sorts of things be escrowed so they can be accessed by the buyer in the case of force majeure, and so on, that the seller personnel or engineers be available to assist the buyer, and that you have access to suppliers and subcontractors of the seller. Other issues associated with that. Another more limited step-in right has to do with upstream suppliers. There, what you're saying is, we're not going to manufacture, but we're going to go get the components and raw materials we need directly from your suppliers, your vendors of seller. We have a right to directly purchase. It can be for generally or for specific components. You can require the seller to disclose in writing the identity of its supplier to provide information, all the agreements that they enter into with pricing and so on. You can require that all the upstream vendor contracts make the buyer a third-party beneficiary, giving them the right to buy directly and the right to enforce upstream supply agreements if the upstream vendor for the seller is balking. Now, the last thing I'm going to talk about, we have about 10 minutes left, is what is known as an efficient breach problem. And we've talked about a whole series of potential tools you can use in order to shift, in some cases dramatically, materially shift the risk off the buyer and back to the seller, the one that is suffering or experiencing this force majeure, through no fault of the buyer. certainly. But you need to pay attention to what the seller's going to do if that burden becomes too great, especially where there's an active dispute over the occurrence of the force majeure, or the scope of the force majeure. We're going to talk about efficient breach, and some of this may surprise you, it may not. I hope it doesn't. Under common law, a party always has the power to breach a contract and walk away, and then suffer damages. It's called an efficient or economic breach. And it's perceived to be socially beneficial because of the freedom of movement it creates within an economy or society, so that you're not engaged in a contract that is ruinous to you and makes no sense, in effect. Now, if the force majeure scope, or the hell and high water clause, if you're really hardcore, doesn't allow the seller to get out, the seller always has the right to efficiently breach the contract and walk away. And the problems for you as a buyer when that happens are manifold. And I will tell you, not frequently covered in other provisions of the contract that will be invoked by the seller to avoid what you think they're going to be liable for if they efficiently breach the contract, when all the other avenues have been foreclosed to the seller. They're involved in a force majeure that they can't get out of. They have an obligation to perform, but a power to breach. So what happens if the seller breaches? Well, the buyer is immediately deprived of whatever performance, resources, components that it needed to discharge its own downstream obligations to its customers. The fact that you think as a buyer you can be made whole is not the case. Let's assume you have a consequential damage or lost profits provision in your contract, or a standard, somewhat standard limitation of liability clause. Now, a standard consequential damage clause, standing alone, is generally going to shield the seller from liability claims based on any separate agreement you as the buyer have with third parties. There's some exceptions to that, but as a baseline. Consequential damages occur when the damage occurs in a third-party relationship as opposed to the direct relationship between the two parties to the contract itself. That includes downstream customers. So any claims that arise because of that? Oh, some folks say they didn't hear it. Sorry. Olive oil. Olive oil is the code word, the secret code word. Now, so a lot of potential damages will be excluded by the consequential damage provision, which is also not mutual and basically benefits the performer of services and sellers. That's a separate issue for a separate time. Same issue. The idea that a consequential damage provision is mutual is fraudulent. Don't believe it. Reconsider your own thinking on the subject if you believe it is mutual, because it almost never is. Now, you can carve out a lot of losses, including lost profits, in a properly drafted consequential damage provision, even if the entity breaches. And then you can have cap liability at all. If you have a liability of $1 million and you're suffering $20 million and they walk away from the contract, that's what a limitation of liability clause is. Limitation of liability clauses assume the other party is liable, but you're limiting the liability for their actions. So consider the following as we wrap up. We're right on time. As a buyer, you should consider the following additional tactical drafting choices that are outside of the force majeure clause but are relevant to it, which is why we're mentioning it here. You should have specific carve-outs from the limitation of liability clauses. In my view, as always, depending on which side of the table you're in, if you're a buyer, certainly, for any intentional breach of the contract. You can even call it an efficient breach. Any breach of the contract and any breach of the force majeure clause, which gets you where you want to go on mitigation, because if they fail to mitigate and there's a breach, that failure to mitigate is just a breach, and it's subject to the same consequential damage provision, the same cap on liability, and so on that exists otherwise. So you want to carve out intentional breach and breach of the clause in the consequential damages provision, lost profits exclusions, and so on. This will subject the seller to unlimited damages and give you, as a buyer, better prospects for collecting your damages. You also should consider the same approach in dealing with indemnification and defense provisions, which require the seller to fund and pay for any downstream third-party claims arising from the breach or even arising from force majeure. Even if the seller's not at fault regarding the force majeure, as a pure allocation of risk and a pure allocation of economics, you can still require them in an indemnification clause to provide that in the event of a force majeure, I will indemnify you for any third-party claims. I can't remember if I've ever even seen that in a contract, but I will tell you that certainly in the context of the times we live now, you should very actively consider it. Finally, we're dealing with issues of delay and termination. So, consequential damage provision, general liability, limitation of liability clauses, and indemnity and defense obligations. You've already required before that they have to discharge their indemnity and defense obligations by carving that out from their excuse from performance of the force majeure. Now you're actually requiring them to actually indemnify you for the economic and other effects that occur in the case of force majeure. Again, allocation of risk. Never done in a standard clause, essential in every clause. Now, you can have a termination right for non-performance. You know, buyer always has a right to terminate if the seller doesn't perform. And that right would occur here. But you should consider at least the option to immediately terminate at T0, at the moment of the force majeure, and just bail out. Especially true if you're dealing with commodities, you're dealing with generally applicable services. If you have lots of options available to you, get out. Not your fault, not their fault, but otherwise you're stuck with the contract. And these are examples of a couple of clauses which will address that. You also obviously can provide a termination for convenience, which allows parties to get out. That's usually for any sophisticated contracts where the parties each have some leverage. It's unusual to see those. Less so in a less sophisticated agreement dealing with commodities, for instance, but still. Obviously, if you have this and it's mutual, then it obviously provides a backdoor for the party who's unable to perform to get out. And then if the seller maintains a termination right, for instance, they're the ones that have a convenience right, the buyer should negotiate for post-termination assistance to minimize the additional effect of that termination. That's generally the case. It's absolutely true in the case of force majeure if the seller decides to just pull the pin on that one. And as I indicated before, you should consider extending the period of performance to deal with the force majeure period by tolling the obligation to perform, and possibly expanding the end date of the contract to take into account a force majeure period when you wish the parties to perform for you. Now, we've talked about a lot of things today. And these include the concept of supply chain, the concept of force majeure in the statutory and common law area, the structure of how these clauses work as a risk allocation, conscious or unconscious, I will say, the particular parts of the force majeure clause, possibly some areas of objective confirmation of the existence of the clause, and some rapid fire or accelerated or expedited procedures you can adopt in order to get to the bottom of whether that clause exists, and then will give you as a buyer, in this case, the right then to invoke the other remedies. We talked a lot about mitigation. We talked about a whole series of remedies that are rarely used but should be considered every time you have a contract of any consequence when they're a recipient of goods or services. We talked about the trap that can lay wait when there are efficient breaches or breaches by a seller, where your intent is frustrated and your expectations are limited, maybe dramatically limited, because of general provisions that you've never thought about syncing up with your force majeure clause, whether it's indemnities or whether it's limitation of liabilities, or particular but not excluding consequential damages and lost profits. That is our presentation. We're exactly on time. I really appreciate the opportunity to have presented to you today. I know we went through a lot of material, that's why it's all written down for you. And I hope that you can take this and use it in your practice. You can take a look at this flow chart, which will be helpful to you. And I thank you for the opportunity to speak with you today. Take care, especially these days.